Hello, take a seat.
All right, shall we get started, everyone? Okay, so I just been walking around a few tables, just checking on the progress of the 10, 12, 13 of you. So far, it seems pretty good that everyone is on top of things. I just want to say a few things before we get started for today. So I believe most of you have started on sentencing this week. It's the second week of the criminal law. For faculty, for me, it's the fourth time you're seeing me. And I do recognize that there are many, many questions on like, or maybe sometimes inconsistencies or sometimes just not exactly sure what's being tested. And honestly speaking, like it's very normal for this kind of things to happen. But what my recommendation is to really go with what you have on Moodle, because after all, it is your chief examiners who set your exam. That's a very delicious apple, by the way. It's after all your chief examiner who set your exam, and they are the one who are in the most position. So if your tutors or if me say anything that's different, do go according to them, because like really they are the people who create this one. All right, but that being said, since we do have access to Moodle and what's in there, I would be providing you with some tips as well on what kind of information you need exactly to study for the two upcoming quiz. It's also important to note that go back to here. All right. It's also important to note that all you are doing so far is all introductory nature. I heard a few conversations about visiting the course as well before this session, and basically, so far the introductory nature of things will get you like the first 20%. It's just something to get you started, but this will probably be the last week that we'll be covering like introductory nature things. Afterwards, next week we'll be having a full revision for your quiz, but afterwards, week 7 to week 12, we will go full-fledged into doing questions that are problem nature. That's when the kind of problem question is when you're going to do it for the rest of 4 years. So giving you a scenario and you writing out your response for 20 marks, 25 marks, 30 marks. These are all introductory nature. So this leads me to my lesson outline today. So first of all, I just want to share some simple tips about MCQ, how to score well, what kind of questions you kind of can expect. I mean, it's very tricky and it's really important for you to have sufficient practice to do very well. And then we'll be continuing with the content. So we'll be looking at mens rea, which is topic 3.3, concurrence and proving crimes is 3.4. Sorry, there's been some typo on the slide. So it's 3.3 and 3.4. I will be looking at sentencing framework again. In a sense, I'm not teaching you anything in relation to number 4, revising sentencing frameworks, but I'm really just telling you what you need to go and study for topic 2. Because teaching you that again takes like 3 hours, but I'm just pointing you out, and you've already experienced some sort of teaching in class. So I just want to show you what you need. Okay, what's the framework, what's the scope of the exam? Because sometimes we do point, or if you do use outdated notes or any sort of things like that, you will receive information that is like really overwhelming, but it's not necessary. Finally, I prepared 4 revision questions. One announcement for next week as well is we will be doing the 20 multiple choice questions, 10 on sentencing, 10 on elements of a crime. So I'll probably be doing a pen and paper. I'll come to that in a moment. It can be in person and online, but I will be giving the top prize, LSS jumper worth $50 of your choice. So and that will only be available in person to just encourage people to come, and that will also help you with your preparation. All right, question please.
Are you still running it during like the?
Oh, no, sorry, I'm not running it the week 6. I mean, yeah. So yeah, that will be week 6. All right. All right, let's continue. So we start off with a simple warm-up first on sentencing, since we already did sentencing today. So so I want to illustrate one point. It's really about understanding the details and nuances. Just think about it. Once everyone here studies the same lecturer, same tutor, probably similar number of hours. All right. what makes you so different that you deserve a high distinction? One of the things is here. So let's try this question together. According to the Sentencing Act, sentencing can only be done for certain named purposes. These are, and then I listed a few. All right, I'm just going to give everyone 1 minute to read through the question. Feel free to refer to your notes as well. And I will ask a show of hands after 1 minute. All right. Okay, who here thinks is option A? Show of hands. No. Who here thinks is option B? No. C? 1, 2, 3, 4, quite a few. D? 1, 2. All right. I just want to ask, like, okay, for the two of you who say option D, what made you arrive at the decision? What did you think of? What did you refer to, or you just happen to know that? Go ahead.
Under the sentencing act.
Yeah.
It's not just punishment.
Okay, so under sentencing act, you say there will be denunciation, community protection, and protecting public interest.
Not specifically, I don't think, actually, no. Say that it's not just punishment.
Okay, so you think it's not just punishment. All right, good. For the majority of you who do raise your hands and put option C, one of you wants to explain to me how you arrived at option C?
Yeah, I mean,
It's outlined in the sentencing act. The just punishment.
Yeah. Oh,
all right.
That would have been like just those three.
Oh, no, no, like just punishment, no, yeah. No, that would be broken English, you wouldn't see that in the exhibits. Okay, if it's like just punishment. They will frame it in like a very formal setting, be like punishment, retribution, rehabilitation, only something like more sophisticated. But anyway, like the idea behind this is really your ability to understand everything. Like, for example, punishment, just punishment, in a way which is just in all of the circumstances. So just punishment is one of them. We do have deterrence as well, under section B, and we have denunciation, number D, manifest denunciation. So if we go back to this one over here, oops. So if we go back to this one over here, like some of the common errors that students might make, and that distinguishes the students who don't get the mark and students who get the mark. First of all, they don't understand the question. They thought just punishment and retribution, that's one. But that didn't come to me. Like the thing that came to me was people trying to use logic and be like, oh, denunciation, community protection, and protecting public interest, or retribution, or social fairness, bringing some philosophical theories and stuff. Like you might think they're valid, but they're just not there. So it's just things that you kind of have to be attentive to details. And like at the end of the day, you get the marks, you start blaming yourself. Oh my God, why did I not read this part? Like, just prepare yourself now. All right, so now this leads me on to mens rea. We'll finish up these two, and then I will be able to go through some revision. All right, so mens rea from reading guide or from the reading list. Basically, we're looking at a few things: intention, recklessness, negligence, and strict liability. Just to make sure we are all on the same page. This topic we're discussing is topic 3. Okay, so we'll be looking at elements of a crime. But only doing for like 20 minutes or 30 minutes, 20 minutes, probably just to give you an overview. And then I'll go back to sentencing because I'm just going to finish everything up before your mid-semester break. All right, and then you could have the opportunity to learn this formally again in class once week 6 reopens. Week 6 I will not be covering any new content. So really remember, like we talked about actus reus last week. This we're looking at mens rea, mental elements. So there are 3 there are three sort of mens rea or mental fault elements: intention, recklessness, and negligence. And we want to consider the difference in all three of them. It may seem to you that intention is pretty easy to understand, but when it comes to recklessness and negligence, they are legal terms that they are not, in a sense, just normal book definition terms. All right. Especially when it comes to negligence, it's quite interesting to see the kind of definition. You will see negligence under topic 7 when you do manslaughter by criminal negligence. Negligence usually arises when you have very serious offenses. It's not easily there to just, some simple offenses. All right. So this is taken from the sketch notes. So I just want to create some sort of definition for you. I'll get the class to read through this for a minute first, and then we'll start discussing them. All right, so I believe everyone has some sort of good understanding. So I did draw something on the board. So we will talk about elements of a crime. We have AR and MR. So AR is when some of the contentious issue we have will be voluntariness issue. When we have the Ugo and then step into the victim, and then we have causation. We look at habits, blow, these kind of cases. All right, so and then regarding MR, we have intention, reckless, and negligence. Today, I'm not going to talk to you about all these cases. In a sense, you will be exploring these cases more in depth in topics 4 onwards. But I just want to give you the simple definition. This is something that you could use when it comes to preparing your exam scripts. All right, so when it comes to intention is pretty straightforward. We kind of want to, the more common definition over here is that the defendant subjectively wanted to cause the kind of specific outcomes. So for example, if I was not happy with a person that just walked past just now, I think he shouldn't be walking past, he disturbed the class, and I took a knife and I stabbed him. Right, so that would be intention. I subjectively wanted, okay, to cause the kind of specific outcome. Okay, to stab him, and as a result, caused him serious injury. Okay. Versus, for example, when I was walking past the class, there was a person behind me, and accidentally, for some reason, there was a knife poking out of my back. And as I was walking, and then I was like swinging, and then the knife poked the person. I wasn't deliberately doing that, for example. Then that would not be intention, because I did not subjectively intended to cause the kind of specific outcome. I just wanted to walk. But another thing that you want to distinguish is whether the defendant merely intended to perform the act itself or wanted to cause the kind of specific outcome. This is 2 different things. I could, for example, let's just use another simpler case. For example, I go to Macca's, I order the double McSpicy or something, right? I wanted to perform the act, but maybe I don't want the specific outcome of gaining weight. That's kind of thing. So for example, I could have stabbed the person that just walked past, but maybe I thought there was a toy knife. It was a toy knife that wasn't sharp, just to scare the person. But I didn't realize the knife could actually still be so sharp that it stabbed him. So for example, like things could come to complication when I took a knife, but the knife was a toy knife, right? And then I stabbed at the person. I thought it wouldn't cause any harm at all, but it turned out to be a very sharp knife, even though it's a toy, and caused him serious injury. Okay, will I still satisfy the requisite mens rea? That's when you have to bring in a lot of discussion. But I think the main point of differentiation that you need to know for now is this: first of all, understanding what intention is. Second of all, understand the difference between intending to perform the specific outcome and intending to perform the act. Okay, when it comes to sexual offenses, for example, rape, it is probably enough to just perform the act of penetration. Okay, you can't really intend to rape. So that would be a bit different. But when it comes to murder or homicide or offenses related to person, then there will be a difference. All right, when it comes to recklessness, this is a bit more interesting. We talk about the foresight of probability. So recklessness is quite different in the legal sense compared to the common understanding kind of sense. When we look at this idea of foresight of probability, would you kind of foresaw that something, as a result of your actions, that something would happen? Okay, so that is something that the outcome, you see the things in green part. It could be apprehension of physical contact, physical force injury, serious injury, death. These are all under offenses against the person. And honestly speaking, the exam, like once you state the law, the rest of it will really go on to application. I will provide you with some examples of this, but these are just literally just common definitions. Finally, we'll talk about negligence. Negligence involves a really serious or gross falling short of the standard of care required by a reasonable person. So for example, when I was walking past to class just now, if I accidentally put a knife in my bag and I didn't realize there was a knife and I went to swing the knife, it pokes the person walking past me, that would probably fall under negligence, i.e. there was a gross falling short of the standard of care required of a reasonable person. Like first of all, why on earth do I have a sharp knife that is in my bag? Second of all, how did the knife just poke through my back? Like these are all questions that you kind of want to consider. Then we have strict liability offenses. This will not get tested in the sense of your final exam. Like none of the offenses you're going to learn are strict liability, but it may get tested in your MCQ quiz. I have no idea. But this is when your MR is not required at all. So for example, we talk about red light. Okay. As long as you beat the red light, you get a fine, $482 with 3 points. The actus reus is literally you running past the red light and get caught. You don't need this at all. All right, so that's the idea of absolute liability. All right, any questions? No? This is a very simple summary of concept. I don't want to go into this too deep, but really just giving you an understanding. I will leave the cases for you guys to read yourself as well because it's still 2 weeks. All right, so let's look at a sample illustration. So again, I'll give the class 1 minute to read this, and we will talk about this in a moment. This did happen last year, by the way. There was a fire, wasn't perfect, but they closed for that.
I think the fire happened, I think that would have been important and the bomb stuff. So I checked this, this is where it's scans. Yeah, like what I have been going through on my road, I think I see what we would have been. if you said that the action directly led to yeah. So that's her defense is like that. Genuine mistake on, but did she know that she know that was out? So she didn't know.
All right, we do have quite a few interesting responses. So first of all, who think is A, intention? She intentionally set up the flammable substance. Who? No one. All right, very good. Who thinks here is an absolute liability?
Clarifying question.
Yeah.
Did she know that substance, did John know that substance was flammable? That's the one clarifying question.
That's the one. Does she know whether the substance? So if you read that,
Because it says.
so she added it, but it was by accident.
Yeah, but did they know that the substance was flammable?
Did they know? Did she know?
It's one thing it adds by accident, but in an ordinary setting, would John have been aware that the substance is flammable, it's dangerous?
Okay,
That
so
that changed my answer.
that changed the answer. Do you think whether or not she knows? Why did I put she? Maybe yeah. She added a flammable substance, and you think whether John knows whether it's flammable makes a difference.
Yes. Well,
So if John knows that the substance is flammable and he added it by accident, versus if John does not know the substance is flammable and he added it by accident, that will make a difference to your answer.
potentially just go for interpretation.
Okay, could you explain to me how your answer changed with that?
If say that they're working with burgers and it's just in bottles,
Yeah,
and I'm thinking, is it just an unlabeled container? Like, it could be anything, you just assume it was something else. Or in a rush, it says, hey, this is gasoline, but in a rush, it just doesn't look.
Yeah.
He doesn't double check and then he pours it in. Because
that will make a difference to your answer.
the mysterious substance was still put in unintentionally, but one makes it the accident. I don't know.
Okay, do you think the fact that?
Between B and C, it changes betrayal linked to this.
Alright, very good. Okay, so we do have some contention over here, and some people do think that there is not enough information. You will experience this a lot throughout your law school. Like sometimes they ask you to write a 2,000-word research essay, they give you one paragraph. Be like, your client seeks your information and advice. The turnover of this corporation is $50 million. They engaged in exclusive dealing, and the exclusive dealing is set out. You may require more information. You're like, what on earth are you supposed to do? And you write 2,000 words based on no information at all, pretty much. So this is where we really have to think. You see, I'm giving you the hard question. I'm not going to come here give you guys simple questions that I believe everyone can do well. Like you will get simple questions, but you will get something like that as well. First of all, we are all choosing between B and C, am I right to say? Okay, who here thinks the answer is B? Show of hand. One, based on whatever you see over here. Okay, who here thinks answer is C? 1, 2, 3, 4, 5, 6, 7, 8, 9. Really? Alright, one of you wants to explain why the answer is C and not B. Not saying it's right, but just. Right, you want to try? Yeah.
I mean, as one, she ordered you to right? So by adding the flammable substance, she felt below that duty of care that she owed. So because of that, she was negligent.
Probably right, but my question was, but was the person aware that it was flammable?
Alright, very good though. Okay, so the answer over here is actually indeed C. Okay, I'm going to explain why this is the case. First of all, we just by looking at the definition of both negligence and recklessness. One is the foresight of probability that something will happen. One is growth falling short of the standard of care. The fact tells us that she is working in GYG. Okay, so she would have undergone some training presumably to know about flammable substance. Like the fact that you're working at a food restaurant, you probably have to go through some kind of training, and you probably know which substance is flammable or not, or at least a reasonable person would have done that. So by her not doing there was a gross falling short of the standard of care required by a reasonable person. That's the first thing. Second of all, if you do look at the case of Needham, which is something I do look at, I'm not expecting you guys to know, but like Needham was literally a case about someone burning down and then helped to be negligent. So that was like analogy by fact. So that's also a benefit of you reading the cases. In a sense, like a lot of these questions, you just get very inspired by cases. Like that happens all the time. And then your faculty or me will just put in like things that happened here and there because I taught criminal law last year. And then just nice back then during 26th of March 2023, GIG closed for like 10 days from like 15th to like 25th or something like that. And then I just put this question inside. So just nice, I just changed the date. All right, so that also leads me to the next point. All right, we talk about topic 3.4. This one again is quite interesting. We're only looking at Fagan today because I just want to prove one point. You could look at Table Valley yourself as well, pretty much about the same point. Okay, so let's look at Fagan. So I will give the class again 1 minute to just read through. Sorry, actually let me summarize a little bit of the facts of this case because I recognize it's not that detailed. So Fagan, the defendant, accidentally rode his car on the policeman's foot. Okay, the policeman say, okay, get off my foot. He accidentally, okay, Fagan rode onto the foot, and the policeman say, get off my foot. Okay, and then Fagan say, no, I don't want to do. Okay, his actual words were like much more mean, like vulgarities and stuff. But yeah, the idea was he didn't want to get off the foot when being asked to do so. But he argues that there was no assault or there was no like any other offenses because you know, yes, he did try to he can't be charged for omission, but he can't be charged for not going away or driving away from the foot. He just simply stayed there. That was his argument. He stayed there. He didn't intend to drive onto the policeman's foot. Okay, so you can't charge me with intention. But at the same time, during the second part of this offense, I was just not doing certain things when being told to do so. You asked me to move away, but I don't. How can you charge me with something because I simply don't want to do? That was his argument. Okay, but the prosecution wasn't happy with this. So I'll give you guys 1 minute to read through the outcome and shouldn't be outcome and outcome. Should be outcome and the legal reasoning behind. All right.
But John really didn't even have any satisfaction, so he didn't even have a little bit of pleasure. That's why we're looking here. So it's like a scale.
So that's the easiest way to think.
That's yeah. There's one of these.
All right, let's go through this. So the main thing we learned about is that we talk about concurrence. On topic 3.4, we say concurrence or contemporaneity, like AR and MR must happen at the same time. If I took a knife to stab the person who just walked past, I must have the AR, which is the act of stabbing, but at the same time, at the moment when I was stabbing the person, I wanted to cause death or really serious injury. It cannot be the case where I stabbed the person and once I went home like 2 hours later after having my dinner and after working out, I say, oh goodness, I wish the person could have died just now. Not the case. AR and MR must have happened at the same time. All right, so that being said, what it was held was that because in Fagan, Fagan accidentally blew onto the policeman's foot and would not get off an ask. What the judge said in the end was that the AR and MR, where the AR is a continuous act, like maintaining the wheel on the police officer's foot, MR may be, quote, superimposed at any stage, as long as it could be characterized as a continuous episode. So it was a continuous episode that you drove onto the policeman's foot and you refused to move away, that would make the MR out. Okay, so two things you can learn from this case. First of all, AR and MR must be contemporaneous. This must happen for all offenses, not most, all offenses at least this course. All right, most offenses in real life. And then we talk about superimposed. So, you know, sometimes they could create a case for you, be like, based on faith, be like you drove on someone, you stepped them, and you refuse to do something, and because of that, you got charged with an offense, then you have to quote Fagan about this contemporaneous idea. Okay. Now when superimposed. How do I explain? Superimposed. Okay, superimposed. Anyone can help me with this?
Think of it like a projector.
Can be projected onto. Yeah. Yeah. So like MR may be projected onto the AR at any
So the
stage.
scene, so like the wall is what's happening.
Yeah.
It can be imposed at any point. It doesn't, like, you don't get to pick and choose.
Yes, you can be imposed at any. Does that answer the question? All right. Very good. Okay, so just now as well, there was during the break, I also received like a question regarding this idea of recklessness, intention, and negligence. Like some of you might still not understand. Like to me, one other way to help me understand this idea was that I think of intention as 100% intention or 90% intention. Think about recklessness as like you kind of foresaw it happen, but you don't really know. But at the same time, you disregard that something might happen. Maybe 20% intention. Okay, and then you think about negligence as like, yeah, you 0% intention. You just didn't do what you're required to do. You're careless, but I didn't intend it to happen. So in our case, John was literally just doing what he was supposed to do, but he just didn't care. He didn't want to have any sort of intentions to burn down the GYG at all. Let's say we have a different example. Let's say just now I was walking past the guy walked past me, and I poor little guy, he just walked past, and I use this example for the whole class. But let's say the guy walked past me, okay, and then I took a fake gun. I thought it was a fake gun. I shot at him, and then in the end, he died because it turned out to be a real gun. All right. So do I have intention to kill him? Not really. I took a fake gun. But would you say I'm reckless in that sense? I had a 4% probability that if I took any kind of gun and shoot at him, that death or really serious injury would occur. That would be the sense. I was not negligent in that case. I did have some sort of intention. So that could prove a different point. So you could think of it as 100% intention, 20% intention, or 0% intention. Kind of. A toy gun, yes.
Sometimes even the toy pills can be quite painful, like rubber bullets can still break bones.
Yeah, but let's say it's rubber, that sounds like.
I could really like.
But then someone's loaded with an like real, somehow like mechanically make the head shoot.
Yeah.
Can you argue that like no?
I could argue that I have no idea, but would I fall short of the? I could potentially go into recklessness. I could potentially go into negligence in that case, right? So if you do get something like a problem question like that, what you're supposed to do? Discuss everything.
So in your scenario, they're saying like it's kind of like painful that like you know that there are situations where
Yeah, I could have.
the person's being like.
So it could go to reckless, it could go to negligence, that kind of thing. Like really, I don't think your exam will go into that bad in a sense, but yeah, like when we have really clear cases, like to be honest, like the question we showed just now was really clear because neither did have what is that? Precedence? Yeah, precedence on on this case about what negligence is. When it comes to regular, sometimes it's a bit difficult. That's why when it comes to week 7, 8, 9, 10, when we look at homicide later on, we're going to, for every murder question, it's going to be 15 to 25 marks. We're going to discuss intentional reckless negligence. And I don't even care about the answer because that's all the exams really hoping you can. All right. But I was just trying to illustrate the point about the difference in terms of the scale. Okay, that's pretty much all I have for the introductory things. We are pretty much good on time. Okay. I'll spend some time just like you're not going to get any information in the sense about content-wise, but I'm just going to tell you how you could prepare because the quiz do get released next week, or if you can wait till after our discussion, it stays until like 10th of April. So I'm going to tell you what to revise. Okay, so this is directly taken from Moodle, nothing that I add. First of all, few things you need to revise topic 2-wise, sentencing, powers and process, sentencing hearing, sentencing framework, i.e. the Sentencing Act 1991. If you do go to tutorials, your teacher might give you other things, but really if it's not here, I wouldn't bother that much. Okay, sentencing options. All right, so again, all this taken directly from Moodle. Nothing new. So first of all, when it comes to sentencing, like that's how I would study at least. I will look at Criminal Procedure Act, section 60, 61, 2000, 207, 209. I will print it out beside me as well. I know not a lot of people print it out, but I will print it out because like it kind of allows me to review because you only have 20 minutes, right? Think about it. So like by it having side by side beside you is really helpful. And also you're doing something that's different. Like say for example, yesterday I have an LSS tutorial participation. Like all I did was I just printed out the notes and then I brought the flower into the class just because they were giving out flowers as well. And then the tutors just say, oh, you came in so well prepared. But I was like, no, I just printed out things. You know, like just doing something that's different that helps you, or maybe do something that works for you might really help. So from the Criminal Procedure Act, you will see what sentencing indication is, what kind of conditions they might give you a sentencing indication, difference between summary and indictable offenses, what we covered in week 2, and then the system, who benefits, who do not benefit. They might have a question on which is a benefit or advantage of this system, and they give you the options to choose from, possibly. This is like your syllabus for the quiz, what to study, what not to study. In relation to sentencing hearing, first of all, you want to read through the Victorian Sentencing Manual. So go and find out where this is. Look at the plea mitigation. Look at chapter 2 of the Policy Director of Public Prosecutions for Victoria. Again, we talk about this in week 2. Look for the statements again, Victoria Sentencing Manual, and consider the few things. Again, you might have some certain kind of questions based on this. All right, when it comes to C.
So do you think it's a good idea to make notes on those? Like it says to just read or skip, right? Do you think it'd be good to make notes on them as well?
So just let me go back. They say skim through chapter 2. So if it's skim through chapter 2, I probably wouldn't in a sense. But when I read it, I will think about how this could be tested in form of an MCQ question. If they do give you a lot of history in the policy, why this law was made, that kind of things, I probably wouldn't. But if they, for example, they could list down, okay, here are some sentencing principles, deterrence, denunciation, A, B, C, D, that probably might make some sense in a sense. Okay. That's a very important skill as well. I was reading through Moodle, I saw something that's like 1,000 pages this morning. I was like, what on earth are you supposed to read this? So I was like, no, I'm not reading it. You know, so just be very careful about what you read as well. This one, sentencing framework under topic 2, part C. This is very simple. The only thing you need to know, better not say the only thing. The main thing you need to know is section 5. Pretty much what we did today, and then you might get a question on start of this class, what we did. All right. And finally, we have D, which is the sentencing options. Okay, so this part over here, there is quite a fair bit of things. You need to look at section 6, 7, 9, 18, 36, 40, 49, and blah, blah, blah. The best way to learn this is really just go through it yourself. No point of me reading through it as well. And then look at the Bolton and the Queen case as well, and just consider, okay, what kind of what the fine do, what the community correction order do, what the imprisonment do as well. Why is it the last resort? And they might ask you some questions like that as well. Shouldn't be that hard. Have your notes ready with you. As long as you go through these things, you'll be fine. But if you go through a lot of things, and go through like things that's out of syllabus, and you don't know what to study, and you go here and there, you'll not be fine. All right. So that's pretty much my advice. Any issues before we move on to final practice questions for today? We're doing a lot of practice questions. 4 more to go. No? All right. So we did mens rea and the concurrence of crime. I'm just looking at mens rea for the next 4 questions. Okay. So each question I will give you guys 1 minute to read, and we will go through that. All right. So first question. Which of the following is true about negligence? 1 minute.
Yeah.
There's a reason I'm so.
All right, the answer is B. Everyone is right. Congratulations. Next question. Do I need to talk about anything? Okay, regarding option A, negligence is involved in more serious offenses. Think about this. We could have negligent, we can't really have negligent murder, but like it's not, but like negligent murder is concept to exist. Like you could murder someone in a negligent manner and get charged. If you drive someone, you kill the person, you could get charged. Like last year, I remember I saw someone drove and caused like a fatal accident by a car and they got arrested outside of Monash. Also in March. That being said, if you carry out some less serious offenses, for example, assault in a negligent manner, you probably can just let it pass. Just think about it like that. All right. Now, let's look at question 2. For serious offenses, the type of mens rea required is
Why can't I change it? Yeah, because no one quite knows how to pronounce, so it's all of them.
Because
Yeah, my God.
and so it's not really laws, which is those are like
For instance, say you know, say it's by the way I'm trying to put it, it's like, oh, I know that if I analyze scale out story, but off, and then the next week it turns out he did bring up, but he didn't. I did something. I didn't even have that. But fucking happened. Yeah. Well, no, it is subjective. Serious criminal offenses. Quiet. So not kidding about this, like, what do you need to have based on what is serious? Wait, is the subjective or objective section line? That in interior.
All right, let's go to this one. This is not too sure for most people. All right, do we have time? We have a few minutes. So first of all, I think the answer lies between B and C. All right, who here got the answer? Not B and C. Everyone thinks it's B and C. Okay. So what is the difference between subjective and objective? So when it comes to subjective state of mind, is what you think will happen. So for example, if I think that by me shooting a toy gun at someone else, I wouldn't cause death or serious injury, that's the subjective state of my mind. But objectively speaking, sorry, that's a bad example. By me shooting a real gun at someone and I think that it will not cause death or very serious injury, that's my subjective thinking. But the objective thing to do is if I shoot a real gun at someone, it will cause death or serious injury. So that's objective. Subjective is what you think, objective is what the reasonable person would think. So for most serious criminal offenses, you will have a subjective state of mind. Answer is B, because you can't just charge one for murder when you think reasonably this person should have done this, but you didn't do this, so you will charge with murder. No. All right, let's look at the next question. We're running a bit out of time. What are the most common mens rea elements? This one, let's just do this together. So we went through three things. This is what I call easy question. You shouldn't get this wrong, right? So like in the exam, they're going to give you some free marks like this. The answer is A for this: recklessness and intention. Three things: recklessness, intention, and negligence. Negligence can happen for some serious statutory offenses involving violence, but the most common ones again you need is recklessness and intention. There's no such thing as wickedness or like this kind of maliciousness. These are just terms that people give, but they are not criminal law terms. Finally speaking, we have, okay, mens rea. Again, it's a simple question. Oh my God. What's the answer? B, mental element. All right. D is wrong because there is strict liability offenses. So mens rea do not always need to accompany. Question?
The last slide is the term malice aforethought.
Yeah.
Like,
Malicious. There is a term to describe murder. I think Sir Edward Cook. Yeah, that's right. So that's not the mens rea for murder. That was the traditional definition in 1511 for murder, when Sir Edward Cook discussed murder as the act of you stabbing someone with malice aforethought and what 1 day and a year after having or whatever, blah blah blah. That was the definition. A very specific definition, but it has since been abolished. Okay. If not, that's all for me today. Just remember, if you next week we're doing revising for quiz and quiz for both sentencing and elements of a crime will be really helpful. I'll probably be printing out paper for everyone to do. So I'll probably be printing out about 20. And then after that, basically you guys get, I'll give you about 20 to half an hour to do. And then I'll spend another 10-20 minutes to go through it. If you're here in person again, top price LSS jumper. If not, you can buy yourself. But anyway, that's all from me. I'll see you guys next week. Bye bye.
See you.